Good morning, everybody, and thank you so much for tuning into another episode of Vastola on the Law. I am Jeff Vastola, your host. Apologize for the background noise. Here we go.
The following program is paid for by Vastola Legal. The views and opinions expressed in this content do not reflect those of 850 WFTL. Hey, we know it's early. But what better way to start your day than by getting free legal advice? This is Vastola On The Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
All right, well, thank you so much for that introduction, and welcome to the show, everybody. Fingers crossed today. We're using a brand new format with the radio show so that we don't have any more technical difficulties. Doing the show right now straight through the laptop, so we don't need my low-tech stereo anymore, my stereo speaker, and hopefully when people call into the show with questions of their own, you're going to hear it live on Facebook. Anybody on Facebook Live that's watching, if you want to type in a question, please do that. Good morning, Mom. First to type in. Nice to see you. Today on tap, we'll be talking about Florida Statute 627.737. Cousin Debbie, hello, how are you? That is the Florida Tort Threshold Statute. It's how it's referred. It essentially requires that you have some form of permanent or catastrophic injury in order to be able to claim what we call non-economic damages, which are pain and suffering, loss of enjoyment of life, mental anguish, those types of things. Hello, Uncle Jeff. How are you? I love when everybody signs on in the morning. This is really cool. So I have to remind everybody, I give away free legal advice, but I'm only licensed in the state of Florida. So my advice is really applicable only in the state of Florida. It's important to remember that I might be talking about something like insurance or a Florida statute that may not apply to you depending on where you live. So just be careful to, if you have a true legal issue and if you're in another state, talk to a lawyer in your state just to make sure that I don't send you down the wrong road. But we'll be talking about that Florida statute today. We'll be talking about Florida did a trial run, I guess kind of pun intended, a jury trial in Florida down in Miami, of all places. You know, the COVID hotspot, they decided to do a trial run of a jury trial down there. And apparently it went well. It was a non-binding trial, so it was all experimental. But we're hoping that we can get jury trials started here in Florida again in the next several months. Hopefully, definitely by the beginning of next year. Because, as you can imagine, I'm sure most states have a tremendous backlog of cases set for jury trials. In Florida, the backlog was intense, and typically if somebody would sign up with me, good morning, Aunt Vicky, nice to see you, I would tell people if it's a standard injury type case, if we filed your lawsuit today, which typically we're not doing that, is the first day somebody comes in to talk to me, but I would use it as an example to say if you signed up with me today and I filed your lawsuit today, we likely would not be getting to a jury trial for at least a year and a half, probably more like 2 years. And that was back in February and the beginning of March of this year before COVID hit. Now, other than this experimental trial that was done down in Miami, there has not been a single jury trial in the state of Florida since March. And so that alone is going to create backlog on top of an existing backlog. So when they start jury trials, we are all quite concerned about how long it's going to take to get to trial now, because you got to flush out all the old cases that were pending. Just interestingly enough, I was on spring break in March when COVID hit, and I was scheduled to start a jury trial the week after I got back. And so one of my cases that was a special set for trial, which meant it was definitely going to go to trial, is one of those cases that's now sitting in that backlog among many, many others that are filed and just waiting on trial dates. But anyway, the good news is the trial run of a jury trial down in Miami went pretty well. The way they did it is they did the jury selection using Zoom, and I don't look forward to that at all because I'm so sick of Zoom meetings I could barf. But they did the jury selection by Zoom. That prevented anywhere from 20 to maybe as many as 60 people, strangers, all sitting side by side like this where you can't even move. For my jury selections typically take up to a full day. It's just questions and answers all day long. Very, very monotonous, very boring. I hate to say that. But I recently had to go through it as a member of the veneer panel, which is the potential jurors. And good morning, Gail. And it's painful. I mean, participation in a jury is something that I've always been told is really entertaining. It's fun, it's exciting, it's educational. So if you get selected to be on a jury, don't be upset about that. Enjoy the opportunity. Now, I'm never going to get selected because I'm a trial lawyer, and that's just the way it goes. I'm not likely to get picked. But I had to go through the process. I had to go through the jury selection process it was like the beginning of the year, I think around January of this year. And it was boring. It was long and boring. And it was in a personal injury case. So it taught me some things about what to do and what not to do when I'm picking my juries. But anyway, they did that part of the trials, the jury selection by Zoom. And then once the jurors were selected, they brought them in, they socially distanced them, they used masks and gloves and everything else and made it a very clean environment, as clean as they could make it. So, we'll see. Now, the problem that they said is that they ended up using 3 courtrooms to try one case. And in reality, you just can't do that because every courtroom is full every day. So, it's not a perfect solution, but hopefully they'll come up with something soon. So, just an update on that. Of course, I've got a couple of cases from my trusty Florida Law Weekly that I'll be talking about today. One, these are things that I've been talking about in the recent weeks. Forum selection clause and an arbitration provision. And both of them were enforced in 2 different cases in the state of Florida just within, well, whenever this was published, within the last couple of months was the opinion. So it's important for everyone to understand that when you sign a contract of significance, I'll say, be careful what you're signing and make sure you understand what's in it. Because at least in Florida, the law is that if you sign a document, you are presumed, not assumed, but presumed to have read it and to have understood it. So even if you are, for example, a Spanish-speaking individual and you can barely read English and you don't really understand what you're signing, the signature on the document is a presumption that you've signed it and read it and understood it. So that presumption can be overcome. For example, if you have a Spanish-speaking person that reads absolutely no English whatsoever, and the contract is written entirely in English and nobody translated it for this person, that's what we call a rebuttable presumption. But the presumption is a very strong one. It presumes that you've read it and understood it. Good morning, Lee. How are you? Nice to see you. So, anyway, forum nonconveniens is something I'm going to be talking about here in a minute, and I may have just butchered that word, but it's something you need to be aware of, because if you if you sign a contract in the state of Florida, don't assume that you can use Florida courts to enforce your contract. You have to look at what's written in it. And if there's a forum selection clause in there, which means the parties agree that if there's a dispute, this is where we're going to file the lawsuit, those are very, very enforceable. And you'll see in this particular case, it was an international forum selection clause. So somebody from the state of Texas initially tried to file a lawsuit in Texas, and that got bounced. So very creatively, they decided to try to file the lawsuit in Florida, and that got bounced. And the Florida opinion says, look, you need to go to Germany, because even though you signed your contract in Texas, the parties agreed that any lawsuits, any disputes would be resolved in Munich. So pretty compelling case that I want to talk about. I've probably just given you all the meats and potatoes of it, and then there's another one, arbitration. I mentioned this just the other day. I feel very strongly about arbitration provisions in contracts because personally I've seen how they can affect a case. My personal preference is to always preserve your right to a jury trial. That may sound somewhat biased because I'm a trial lawyer, but I also can arbitrate cases. Good morning, Lindsay. Good morning, Nana, watching from Colorado. Hello, Terry. How are you? So I've seen how arbitrations can affect an otherwise good case. And I say affect because I really question And I have to be careful because I don't want to insult anybody that, you know, arbitrates cases consistently and for a living, because I think every single arbitrator on the planet will say, I objectively listen, I objectively apply law to facts, and I objectively render my decisions. But in my experience, I just think there's a little bit of pragmatism that goes into some arbitration decisions that you don't have to deal with a jury. So if you like arbitration, if you want an arbitration provision in your contract, then by all means agree to it. The point is, there's another case in here that enforces an arbitration provision that was contained within the contract that one of the parties was trying to avoid. So if you're about to sign a contract of any significance, make sure that you read it, make sure you understand it, and most importantly, if you don't understand any part of it, call me, and I'll be happy to give you some free legal advice on what the provisions mean and how they're applied. This is something, even if you're out of the state of Florida, I can't tell you what the law is in your state and how it might be applied in your state, but I can at least tell you what the meaning of the provisions are and how they work here in the state of Florida. If you'd like to call into the show, into the radio show, if you're watching by Facebook Live, you may not realize this is also being simultaneously aired over WFTL 850 AM. And if you are wanting to call in, you can do it. It's toll free. 877-850-8585 is the number to call. Those of you out there in Radio Land that are just listening and you have no idea that I do this by Facebook Live, you can watch by Facebook Live. All you have to do is friend me, and I will be your friend. And on Saturday mornings at 7:30, you can tune in, and you can watch by Facebook Live. But anybody out there that wants some free legal advice, please call 877-850-8585. If you're watching by Facebook Live, you can type in a question, and I'll do my best to answer you. You'll notice that I'm not squinting real close at the screen today because I've got my contacts in. At 8:01, we have to be in the car and making our way to Vero Beach for Giovanna's first soccer tournament of the year. So we're really looking forward to that. We wish her good luck. Somebody's texting me, but I can't get to the text right now. I'll get to that later. So, Florida Statute 627.737. This applies in any kind of an automobile accident. And it might affect your case and it might not. And I'll talk about that in a minute. But if you're involved in any kind of a motor vehicle accident with injuries, then 627.737 might apply to you. It's Florida's tort threshold statute. And that's legalese language basically saying in certain circumstances, in order to recover non-economic damages, you have to have one of these categorized areas of injury. And I'll talk about them in a minute. But the reason why it's really important is because if you go to a jury trial for an accident and your damages are going to be limited to what we call the economic damages, that could be problematic for you. Because if you don't have significant medical bills, past, future, and if you don't have any form of lost income claim, there's a lot of claims out there where there's just no loss of income, whether it's in the past or in the future, then if you don't meet this Florida tort threshold, then you really don't have much of a case to complain about. You're not going to get much of a recovery because the jury's not going to be asked on the verdict form to award you damages for pain and suffering, mental anguish, loss of enjoyment of life, and those types of things. Those are called non-economic damages, and those oftentimes are the portions of an award that are much higher than the economic portions. Now, sometimes the economic portions of an award can be extraordinarily high. So it's not to say that if you're limited to just economic damages that you're not going to do well. I don't mean to say that. But I do want you to be aware that this Florida statute is it's a compelling statute. It's good to know about. But it's also good to know that a lot of defense lawyers just kind of throw it out there in every single case. So they use it as what's called an affirmative defense. They just kind of throw it out there to say, oh, Florida tort threshold because this was an accident. Well, a good plaintiff's lawyer knows how to get around that sometimes because there are exceptions to it. So the stated exceptions in the Florida tort threshold statute. Now, the Florida tort threshold statute says if you can't claim one of these types of injuries, then you're going to be limited just to economic damages. The four enumerated types of damages that can get you around that are loss of an important bodily function, It doesn't go beyond that, so that's up to the court's discretion and perhaps a jury to decide. The gateway decision is the court's decision, and that's why the judge sits. By the way, when you have a jury and you have a judge, you might ask yourself, well, why do you need the judge if the jury is there to make all the decisions? Well, the jury doesn't make all the decisions. The jury just decides questions of fact and will render a verdict based on the evidence that they hear and applying the law that the judge gives them. The judge is there to make all determinations of law. And a gateway question such as this, was there a threshold injury, is a question that the judge will answer. So loss of an important bodily function is number 1. A permanent injury is number 2. And then scarring or disfigurement is number 3. I think that has to be significant scarring or disfigurement. And then, of course, number 4 is death. So any one of those 4 can get you around Florida's tort threshold law, which will then allow you to make a claim for the non-economic damages, pain and suffering, mental anguish, loss of enjoyment of life. Those are really important damages if you're going to be trying to present a compelling case to a jury and ask for any significant amount of money. Now, just because you were injured in some kind of a vehicular accident doesn't necessarily mean that the Florida tort threshold statute automatically applies. And this is where a good plaintiff's lawyer can eliminate this affirmative defense right off the bat, depending on what kind of a case you have. And specifically what I'm talking about is that this statute, understand that this is a little bit of background and maybe too much information, but it's premised on Florida's PIP law. In the state of Florida, we have what's called personal injury protection benefits. That's one of 2 mandatory insurance coverages in the state of Florida. So everybody presumably has PIP. There are some reasons why it might not be applicable, and these are some reasons why that I'm going to talk about in a minute. But overall, the grand scheme of things is in a car accident, there's going to be PIP benefits available to somebody because it's a mandatory insurance coverage. But because of that $10,000 of money that's available for medical bills, lost income, or a $5,000 death benefit, then the Florida legislature enacted this statute to say, well, because of the PIP law, we're going to require some form of permanent injury threshold, or scarring or disfigurement or loss of a bodily function. So that's basically the background for it. I don't think it makes any sense, to be honest with you. But there are some exceptions, as I mentioned. So if you've been involved in some kind of an accident and you've been hurt, don't automatically assume that the tort threshold is going to apply to you. It really only applies in what I would say most car accidents. But here are some exceptions to where it doesn't apply. Motorcycles. If you've been involved in a motorcycle accident, the tort threshold won't apply to you because PIP law doesn't apply to motorcycles for some weird reason. Don't ask me why, I don't know why. Public transportation. If you're on a city bus and the bus gets into some kind of an accident, there's no PIP applicable to public transportation. So there's an accident where tort threshold's not going to apply. If you're a passenger in a taxi, that's not going to apply. In Florida on the highways, we've got these huge lawnmowers that go up and down the medians and on the side, the shoulders of the road, and I would assume typically they're very safe. But if you're driving one of those and somebody goes off the road and hits you and you're injured, you don't have this tort threshold because farm equipment and stuff like that is not going to have a PIP requirement. So that's an exception. And then lastly, which I thought was really interesting, there's a couple of cases out there. The Uber drivers and Lyft drivers, depending on how their insurance policies are written, but because of the way their insurance policies are written, the company policies for Uber and Lyft, the drivers themselves, if they're involved in an accident, and if there's no PIP applicable for them, the Florida tort threshold will not apply. Now, what's also interesting is that it doesn't apply to the passengers in the car. So if you are an Uber customer or a Lyft customer and you're in a car that's involved in an accident, then you very well may have the Florida tort threshold, but yet the driver does not. So, interesting topic, at least for me. If you have any questions about it, feel free to type something in or call me. Radio show's been quiet the last several weeks. I know we've had to run a couple of repeats, but 877-850-8585, that's the number to call into the show. You can be live. You can ask me anything you want. I talk about injury cases. I talk about wrongful death cases, product liability cases, sometimes medical malpractice cases, because those are the areas of law that I handle. But I don't like to limit people to just what I do. And I say this all the time, and I really mean it. I enjoy when people ask me questions that I don't know the answer to right off the bat, because then it forces me to do the research, and it does a couple of things. First, it forces me to learn new things, which is pretty cool. And then it also gives me a topic for the following week's show, because when I do the research and I find the answer to the question, normally I think it's a pretty interesting topic, and it will become the topic for the next week's show. So don't be shy. If you have something going on in your world and you just want some free legal advice, well, now's the time to ask. 877-850-8585. That's the number for the radio show. Let me plug me and my firm real quick, because I might run out of time and I'll forget. If you want to talk to me privately, and I understand, because I've heard this over the years, that sometimes people don't call the radio show because they don't want to share over the radio waves and everybody listening what happened to them, because there's oftentimes a lot of privacy involved. If you want to talk to me privately, you can do that anytime. I have a number, it's 833-VASTOLA. It's a toll-free number. That doesn't matter anymore. Back in the old days, toll-free numbers were really important. But 833-VASTOLA it's forwarded to my cell phone 24/7, and I really encourage people to call me anytime. You can call me on the weekend. You can call me at night. You could call me at 4 a.m. if you wanted to. If I can answer the phone, I will. If I don't, leave me a message and I will call you back when I can. I'm sorry about the bouncing. I got to get my arm off the desk. 833-VASTOLA is 833-827-8652. And use that number anytime you want. You can go to my website to find out more about me and my firm. That's www.vastolalegal.com. Vastola, V-A-S-T-O-L-A, legal.com. And then, of course, all the social media stuff. I haven't been real active the last several months. I got lazy over the summer. But I'm on Facebook, of course, Instagram, Twitter, YouTube, LinkedIn. Every once in a while, I'll put something on there. So if you're interested, you can follow me on those things. But most importantly, if you or somebody you know needs to talk to an injury lawyer, have them call me, and make sure you tell them that there's no obligation to hire me just because they've called me either. I just want to be available as a resource for anybody that might need it. Had an interesting inquiry just this past week about an intentional tort, and something it's not on my agenda for today, but I thought, why not talk about it, because it just popped into my head. But a woman called me. She had been the victim of an assault, and so she was curious whether an attorney would take an assault. Not a lot of lawyers will take those cases because there's no insurance. Most insurance policies, as they're written, I imagine, in theory, if somebody had enough money, they could convince an insurance company to write a policy that would cover an intentional act, but I've never seen one. Most insurance policies are going to cover people or companies for negligence, mistakes. You know what? I suppose there is a type of coverage that might be arguably intentional, and that's advertising and or defamation. So I guess if you have a claim of that nature, the insurance company might be forced to provide coverage depending on what the facts are. But for any kind of an injury, a physical injury, every insurance policy I've ever seen is going to exclude coverage for an intentional act. This woman contacted me for an act that was clearly intentional. And so it's not to say that she doesn't have a case. And that's an important distinction. When talking to a client, I have to be very careful to say, I'm not telling you that you don't have a case. I'm telling you that there's not going to be any coverage for it in my experience. And what does that mean? Well, it brings in the reality of the situation. Most people, when they've been wronged, they want to bring a claim or file a lawsuit against what we call the tortfeasor, whoever was responsible, and they want to collect money. People that have never had any experiences in this, they just kind of assume that the money comes automatically, and it's not comical to me, but it really never ceases to surprise me how people don't realize that the money doesn't come that easy. You could get quick money from an insurance company depending on the facts of the case, You know, the amount of coverage compared to the extent of the injury and that kind of a thing. I mean, sometimes the insurance company is banging on your door within a matter of weeks to pay you the policy limits, but that's typically when somebody's been catastrophically injured and when you've got low limits. But in a case of an intentional tort, the reality of getting paid because you've gone through the process of filing a lawsuit, going to trial, getting a judgment from the court, your case is over, you've won, congratulations, but what does the court do for you? The court gives you a piece of paper. You know, the jury goes home, they go on with their lives. The court gives you a piece of paper called a judgment and says, here you go, you won. This is what you're entitled to. The court does not force anybody to pay you. You can utilize the court, and if you know the rules, you can utilize the rules and attempt to get paid utilizing the rules and utilizing the court, but the court does not become your advocate and does not, you know, go to the defendant's house knocking on the door saying, get your checkbook or I'm going to take you to jail. It doesn't work like that. And if there's no insurance behind the claim, insurance makes it easy because the contract of insurance that the tortfeasor has says, thanks, Rena, that if there's any kind of a judgment rendered, the insurance company has to pay it at least up to their policy limits within a certain time frame. But if there's no insurance, then you've got a long road to hoe. And I'm out of time. Good morning, Maura. Nice to see you. Thank you so much for listening. If anybody has any questions and follow up, if you want to ask me a question in private, if you just want to say hi, call me, 833-VASTOLA. That's 833-827-8652. I'm off to Vero Beach. Hope everyone has a great weekend. Bye-bye.